Structured law has been a part of many societies since as early as 2100 BC in Mesopotamia, meaning that it has many years to develop and to figure out what works and what simply doesn't. However, like most things in the Middle Ages, even law did not escape some vastly unnecessary policy shifts, because when trial by ordeal simply isn't enough, you can really just let them fight it out.
Get him up, let him get up, let him get up, let him get up.
Trial by combat, or battle, was a unique way for disputes to be solved during the unconventional period that was the Middle Ages, being used to settle disputes over such things as land, to cases of insult, injury, theft, and even high treason, with the action itself becoming such a crucial part of European medieval history that scholar Eric Jaeger labeled the practice as being, quote, almost universal in Europe, highlighting just how expansive the use of trial by combat really became, but which regions in particular, and moreover, when and why was it used. The first recorded use of trial by combat comes from the Germanic Lombards sometime around the year 630, when Gundeberga, the wife of King Eriold, was accused of attempting to poison him, which ultimately resulted in Eriold sanctioning a duel between the accuser and a champion in the name of Gundeberga to determine her innocence. However, the first recorded implementation of trial by combat in written law comes from several Germanic tribes who included it in several of their legal codes, with one of the earliest being the Burgundian Code, written sometime during the early 6th or 7th century. And following the Germanic implementation of the law, and around the same time when the Frankish Empire occupied these lands, is when we see trial by combat appear in their written law, which included more details about rules, such as restrictions on weapons and rules to combat. The first example of the law in practice within the Frankish Empire was recorded around 712, within the Lex Alemanorum, which recalls two families who disputed land claims through trial by combat, with the partaking duelists recorded touching their swords to a handful of dirt from the disputed land, which acted as a lawful agreements from both parties. Moreover, it is recorded in this instant that the loser would have to pay an additional fine on top of the lost land. Furthermore, from the 800s onwards, Frankish law would see notable legislation around the act, ensuring that it was governed fairly and effectively, with Frankish law articles citing judicial dueling as a prominent act for legal resolution. Moreover, it is during this period that Louis the Pious, king of the Franks, recorded an instance of trial by combat himself. However, in his record, the duel would be fought between two witnesses rather than those actually in dispute, which appears as a rather obscure outlier from the traditional duels that are often seen. This particular instance may have been the trial from 834, which saw a dispute between monks lead to two witnesses from either delegate fighting for control over the disputed territory. However, despite this rather peculiar instance of witnesses fighting, it was not uncommon to see hired individuals fighting in place of either party. These individuals were known as champions and were hired specifically for such duels, being offered hefty rewards for their victories, a practice that was used prominently throughout the history of judicial dueling, being seen within very early records up until its final use. However, depending on the region and time period, certain laws accompanied who could be hired as a champion, such as requirements that a champion must have been a witness to the event, or lived in the specific region in which the dispute was taking place. However, most of these rules were short-lived or sparsely practiced, but even so, they did not exist without controversy, such as one example from the late 11th century, which saw French monks hire a strongman to fight any judicial duels that they were tried to. The monks, like in many instances, offered hefty rewards for doing so, which yes, meant that the wealthier an individual was, the better fighters they could afford, with some instances being recorded of these wealthy individuals hiring out all the champions within a certain area so that their opponent would be left to fend for themselves. However, in the case that someone either couldn't find or couldn't afford a champion, but still wanted to avoid a duel, it was not unknown for them to entirely skip the duel. However, if such a thing was expected to happen, the tried individual may have been jailed for the duration leading up to their duel, such as James Butler in 1446, who was held within the Tower of London for the duration leading up to his duel. Additionally, it was during the 9th century and onwards that trial by combat was recorded in much more distant areas, such as several Scandinavian cultures. The action was in the form of holmgang, highlighting just how widespread and popular the law really was during the medieval ages. Further historical records of trial by combat continue into the Holy Roman Empire, although for a number of the years that the action was in use, it was heavily criticized, and much of the discussion around the action was almost exclusively condemning it, which saw saw trial by combat fade in such regions for several hundred years, with much of this disdain coming from Christian synods and emperors, which was seen prominently throughout the Carolingian period, with one recorded excerpt on the topic from a council of local bishops in 855 stating, quote, "The blood of war to be shed in peacetime, with the cruelest of spectacles, we decree, according to the ancient custom of ecclesiastical observation, that whoever kills another man or renders him crippled by wounds in battle, so iniquitous and contrary to Christian peace, should be separated like a worthless murderer from the company of the church and all the faithful, and compelled to carry out legitimate penance in all ways. Furthermore, he who has been killed is to be considered unsuitable for the commemoration of the Lord's prayers, just like his murderer and a voluntary seeker of his own death. Nor is his body, according to the decree of the canons, to be brought to the sepulchre with palms and prayers." And although the following years would continue to see further limiting of the action, such as imposed sanctions in 967 by Otto the Great, the 13th century would yield a much different opinion on judicial dueling, such as the Saxon Spiegel, an important set of local and Roman laws registered in 1230, which would note the importance of the action inside legislation, and even recall key rules for its use, such as rules stating that if a participant missed their duel 3 times, the other would be claimed victorious, and that neither participant should have an advantage by facing away from the sun, noting that both participants should duel perpendicular. However, trial by combat began to spread as a prominent legal action in many other regions alike, such as England, France, Ireland, and Scotland, with the law being included in English common law as early as 1071, following the Norman conquest during this century, and likewise the practice of judicial combat seems to appear as a customary practice in many French regions during this period, being recorded as early as 1008, when King Robert the Pious allowed the Abbey of St. Denis to carry out judicial duels. However, the action would be banned within France from the reign of King Louis VII to King Louis IX, but would be reinstated during the reign of King Philip IV in 1307. However, notably, many regional courts still held duels during their ban, but it prompts the question as to why this law in specific was so favored by these regions at all, and the answer to that is due to the hardship of collecting and verifying evidence within legal disputes during these periods, as many disputes lacked witnesses and had very little evidence to base their claims upon, which resulted in trial by combat being seen as an effective way to resolve disputes, primarily due to the belief that God would favor the right party, providing them with an advantage and therefore allowing them to become victorious. However, there are several recorded instances of both duelists dying, so the validity of this claim was debated in some cases. Moreover, the law included several rules that changed depending on class and other factors, with some records stating that no women, seniors, youth, or disabled peoples would be permitted to use dueling as a form of resolution, and likewise, neither party were permitted to use witchcraft or sorcery to aid them in a duel. Furthermore, as to where duels would actually take place, largely depended on the time period and region, and ranged from the common field or meadow to sanctioned 60-foot squares. But at last, here are some recorded instances of the law in action. In England, 1446, a servant accused their master of treason, resulting in trial by combat. In England, 1200, King John ordered 2 separate duels over cases of theft, as he wished to view them himself, which aligns historically with the Curia Regi's roles, which provided rights to regional jurors to oversee trial by combat within some areas of England. In Scotland, 1396, the Battle of the Clans would take place, a duel which saw 60 men, split from 2 clans, meet at North Inch to resolve a dispute over land claims. The duel was significant enough that it be witnessed by King Robert III. However, concluding the trial, only 12 men out of 60 would still be alive. In Scotland, 1478, the Battle of Champions would take place, a duel between 2 Scottish clans which would be fought at the chapel of St. Tyr's. The battle was meant to be fought on horseback, however, one clan brought 2 people per horse, which unsurprisingly fared quite well in their favor. In France, 1386, 2 Frenchmen would duel following a dispute over suspected actions against one of their wives. The duel, which was approved by the court, would follow after an initial inadequate judicial outcome. The duel itself amassed a very large crowd, which included King Charles VI, who required them to take oaths in front of him stating that they had no magical advantages. Moreover, if the accuser lost the duel, not only him, but his wife too would be found guilty of perjury. The duel is recorded as one of the most prominent examples of trial by combat in practice, and was also turned into a Hollywood movie in 2021. So check that out, I guess. Trial by combat itself in France would begin to slow down after the deadly outcome of this event, and by 1409, the action itself would be outlawed in all courts with the exception of the Parliament of Paris. However, several duels would be recorded in France until about 1571. Moreover, the final use of the law in England would be recorded in 1446. However, it would remain in both judicial systems for a much lengthier period, which resulted in the occasional request for trial by combat within the 17th and 18th centuries, and remained in legislation until the 19th century. And as far as the other regions, it is relatively hard to say. But regardless, the action of trial by combat is indisputably bizarre, but impressively well recorded for what it is, being a very interesting topic to study and examine how the action expanded across centuries and cultures in many different ways. In conclusion, the implementation and use of trial by combat in legal systems would be most prominent throughout the 9th to 13th centuries, and would begin to fade out of practice around the 16th century, finding itself in use in more educational ways, such as German schools of fencing, but would be largely faded as an actual form of judicial action. And lastly, I would like to extend a brief mention to PhD graduate Ariella Elma from the University of Toronto and University of Chicago graduate Peter T. Leeson for their work on this topic, which has been used to source some material for this video. And that really concludes the history of trial by combat. Thanks for watching. If you enjoyed this video, consider liking and subscribing for future content.